Okay, good afternoon, everybody. Thank you for being here. The meeting will be called to order. Can we please take the attendance?
Deasy,
Here.
Benham,
On leave.
Brown,
On leave.
Gerall, Guggenauer,
Leave.
Guzman, Isaacson,
Leave.
Kenyatta.
I'm online.
Oh, I'm sorry. Got Mary's online.
Online.
Sorry about that.
I was trying to look. Yeah, there she is. Kenyatta,
Leave.
Malagari, McAndrew,
Present.
Otten,
Leave.
Powell,
Leave.
Salisbury,
I believe she's virtual.
looks like she's on. I have leave slip for her, so
Okay.
she must not be on.
All
Okay.
right.
Schusterman,
Leave.
okay. Fee,
Here.
Armini,
Leave.
Fritz,
Leave.
Gatos. Oh, she's virtual.
Virtual.
Yes, I think she's virtual.
Yeah. Ledbetter,
Virtual.
Okay, thank you. Ledbetter's leave.
Major, Mahaffey, Mihalik,
Leave.
Mostello, Rigby, Smith, he's
Smith
virtual.
is virtual.
Stare. We have a quorum.
Okay, great. Thank you. Earlier this session, we held a joint informational meeting with the Senate Law and Justice Committee to discuss the work of the Stop and Go Legislative Task Force. Today, we are here to receive testimony on House Bill 1413 by Representatives Bellman and Hogan, which would address concerns regarding stop-and-go establishments and strengthen enforcement of liquor code violations. Over the years, the Liquor Control Committee has been able to accomplish many things through bipartisan initiative, and I hope today's issue on legislation to address nuisance establishments is no different. In advance, I'd like to thank all the testifiers that are here today to provide comments to the committee on an issue that has a long-standing history. With that, Chair Fee, good morning or good afternoon.
Yeah, good afternoon. I'd just like to thank Chairman DC and Lynn for putting this hearing together, and to all the testifiers, and of course the maker of the legislation. So I look forward to learning. Thank you.
Great, thank you. Today, we've invited the prime sponsors of HB 1413 to make a few remarks. Rep. Bellman.
Thank you, Mr. Chairman, and thank you to members of the committee. So-called stop-and-go establishments often appear to be convenience stores or delis, but operate as alcohol outlets using restaurant and retail liquor licenses issued by the Pennsylvania Liquor Control Board. Many of these establishments fail to consistently meet the minimum requirements for licensures, and in doing so, operate in ways that are socially irresponsible. These practices frequently attract disruptive and problematic behavior that negatively impacts the surrounding neighborhood and creates ongoing concerns for its residents. Over time, these non-compliance businesses and the issues they generate have become increasingly difficult for local and state officials to regulate under existing law. In the city of Philadelphia, I have seen firsthand how stop-and-go establishments can undermine public safety and reduce quality of life in residential communities. In 2024, I had the honor of serving on the bipartisan, bicameral Stop-and-Go Legislative Task Force. This task force was charged with examining these issues and developing recommendations to improve enforcement and compliance. That work included a comprehensive review of current law, multiple public hearings, site visits to stop-and-go establishments in Philadelphia, and extensive collaborative work amongst the task members and stakeholders. Based on that work, the legislation implements the task force recommendations by strengthening the PLCB's compliance program, streamlining the citation process, increasing penalties and fines for non-compliant operators, and addressing current court review standards that limit effective enforcement. These changes are necessary to allow regulators more effectively address violations while ensuring the public health, public safety, and neighborhood quality of life remain the priority. I'm confident that this bill reflects a thoughtful, balanced approach grounded in extensive study and bipartisan collaboration. And I want to thank all the members of the committee for considering this legislation. And I also want to thank Senator Williams for all of his work in doing this for many years. As we know, this is an issue that started in Philadelphia, but it's an issue that affects the entire Commonwealth of Pennsylvania. So with this legislation, our goal is to solve the problem and solve this issue. And I hope that everybody can learn something about the issue today and hopefully get it passed on the House floor shortly. So thank you.
Thank you, Rep. Bellman. Next, we have Rep. Hogan for remarks.
Thank you, Chairman Deasy, and thank you, Chairwoman Fee, for having me as well today. I won't go into all the details that my colleague, Rep. Bellman, just did just to save time, but I will stress the fact that in the summer of 2024, this was truly a bipartisan effort. Senator Ferry and I from Bucks County joined Representative Bellman and Senator Williams from Philadelphia. We went on several tours. We saw these firsthand. We participated with law enforcement as they were basically regulating these and citing them and doing inspections. And as it was mentioned previously, this has been a long-standing issue primarily in the city of Philadelphia, but as I think we know far too often is once individuals find ways to make a quick buck, that model spreads very quickly, and we're already seeing in parts of Bucks County some establishments that are getting pretty close to what I would consider stop and go as well. So I want to thank the committee again for entertaining this important legislation. This is I think it's a bipartisan need, and by working together, we can, I think, come together and solve this for every community in Pennsylvania. So thank you.
Thank you. And finally, we will ask the chair of the task force. We're joined by Senator Anthony Williams from Philadelphia today. We appreciate all the time and years of work you've put on this particular issue. So we know how passionate you are about the issue. So please join us.
Years means I'm old. So you're right. Good afternoon, Chairman Deasy and Chairwoman Fee, and members of the committee. Thank you for the invitation to testify on behalf of House Bill 1413. My name is State Senator Anthony Hardy Williams, and I represent the 8th Senatorial District, which includes Southwest Philadelphia and parts of Delaware County. I have served as the chair of the Stop and Go Legislative Task Force, which was established by Act 49 of 2023. And I underscore the bipartisan, bicameral Stop and Go Legislative Task Force, and many of us know we don't have many of these things at work in this building these days. That's why I'm very excited about your attendance on a non-session day. You don't have to be here. And I'm sure more than half of you are going to figure out what a stop and go is by the end of the day. But in the meantime, you're like, what the hell was this problem, right? So thank you for being here. As well as producing a report, including recommendations for how to better regulate these businesses. Our recommendations were passed unanimously and culminated in the legislation being discussed today. I encourage anyone who has not read the report to do so. I want to first express my thanks to the legislators who were an integral part of our task force and important work and important to the work it produced. Thank you to Representative Bellman and Hogan as prime sponsors of House Bill 1413, as well as my co-prime sponsor, Senate Bill 21, Senator Ferry. I also thank PLBC Chairman Darrell Clark and Ms. Swinson for their service on the task force. I would be remiss if I did not thank the working group and the staff who provided support to produce the task force product. Stop and goes have been a long-standing problem in my district and across Philadelphia. Some 40-plus years of stop and go nuisance behavior have driven my involvement in this issue. However, I think it's important to underscore the nuisance behavior at licensed liquor establishments is not only a Philadelphia problem anymore, as a similar issues impact community safety across the Commonwealth of Pennsylvania. So for those of you that are asking the question, what is a stop and go? A stop and go is a term of art that represents Philadelphia colloquialisms and culture. It is a business with a restaurant, it is a convenience store or a deli-style business with a restaurant or eating place liquor license that operates outside the parameters of what their licensing provides. They generally do not adhere to the minimum terms of the license. They usually lack seating. And unlike restaurants, they don't provide a place where you can sit down, casually eat, enjoy patrons, and enjoy a meal. Usually, unfortunately, they are very dirty. Minors are in these locations with adults. They allow for alcohol, a lot of alcohol, fortified alcohol, often sold for immediate consumption inside and outside the stores, including shots. I want you to imagine going to a neighborhood store in your community, going down to get some chips, and you walk into a store where they're selling loosies, selling paraphernalia for, marijuana, also selling candy bars to a 5-year-old child as you're buying a shot right next to them. Literally side by side. Not a bar, not a restaurant, but a neighborhood establishment. These things are hard to imagine, and you really have to actually go visualize them. And I want to thank the members of this committee who took the time, and I'm going to be even more direct. My Republican friends who come from the counties, some actually traveled like 5 hours to see these places. And they were actually stunned that we're allowing this kind of operation to occur in Pennsylvania. And without this kind of regulations, they will continue to operate. They're often magnets for nuisance behavior, which spills out into our neighborhoods, making streets unsafe for the communities where they are located. In order to improve the safety and welfare of our neighborhoods, we need to address stop-and-goes. The unsanitary and sometimes violent conditions cannot be left to undermine our communities any longer. This is not to say we have not tried. There have been legislative efforts on the state level and in city council to try to change the behavior of these establishments. Efforts have been made by state legislators, Philadelphia City Council members, and our regulatory and law enforcement entities. For instance, in 2017, the General Assembly passed legislation to strengthen PLBC's authority to increase their inspections and immediately suspend our compliance license establishments. Despite these legislative changes and other efforts, we still find ourselves nearly a decade later trying to curb irresponsible behavior and improve community safety. Complaints about the noncompliance of these business entities and those effects that have existed for more than 4 decades have not stopped. Our communities and local governments are asking, no, they're actually demanding, and frustrated by the fact that we have not found better solutions. The task force's recommendations and the subsequent legislation we drafted are to date the strongest proposed deterrents to stop-and-go behavior. They streamline the citation process, strengthen the licensing compliance programs, address court review standards, and increase fines and penalties for the first time in 40 years. We arrived here after extensive meetings and hearings involving community input, the regulated community, state legislators, state regulators, local government officials, and state law enforcement. That feedback was taken to heart, much of which was included in the legislation under consideration today. Let me be clear. I want to see robust businesses in my community, my city, and across the Commonwealth. But I want those businesses to be a part of the entire community, contributing in a meaningful way to their social health and economic prosperity. This legislation strikes the appropriate balance between the interest of responsible business owners and public safety. I'm going to leave more pointed testimony regarding the legislation's impact to the other panelists, but I ask that the members approach what you learn today through the lens of your neighbors, kids, grandchildren, moms and dads, as you consider making these changes and positions the bill for a vote. Quality of life will increase exponentially if we can get these business complaints compliant and working in a way that discourages nuisance behavior and increases the safety of our communities. Thank you, Mr. Chairman and members of the committee, for your time and attention to this legislation. Thank you again.
Thank you, Senator. We appreciate your time for being here. All right, we'll begin with the first panel. We have representatives from the PLCB as well as the State Police Bureau of Liquor Control Enforcement. Before we begin with this panel, I must say a few words of thanks today to Tisha Elbert, Director of Regulatory Affairs for the PLCB. Many of you know Tisha's been a familiar face before this committee for many, many years. She will soon be retiring after over 35 years of service with the Liquor Control Board. We just wanted to make sure that we extended our thanks for all your help over the years, your knowledge and expertise that you shared with us, and we wish you all the best as you move forward. So thank you for being here today, as well as thank you for your help through so many years. Absolutely. We want to begin with the panel. Any particular order? Chair Clark? Excuse me, Chair. Can you pull that microphone a little closer and make sure it's on? Just some folks are having trouble hearing online.
Oh, I probably need to turn it on. Yeah, be helpful. Yeah, Representative Hogan and I think Ferry, we did the tour, and I'm off script right now, in Philly, and we pulled up, and I'm sorry I have to tell this story so you'll get a sense of it, and we pulled up in the van, and folks on the van wanted to know, do we have to get off? Because that's what we saw. There were literally people standing outside, shooting dice, smoking weed, drinking, doing whatever, right? And this was pretty much what we see in neighborhoods across the city of Philadelphia. And this is really challenging. And it's just been happening for so long. So the fact that we're here talking about legislation that would give the LCB and the LCE an opportunity to address this very, very problematic issue, I'm just pretty much excited. So I just want to thank you all for hearing us today. I'll try to go through the script. You all know I'm Darrell Clark, Chair of PLCB. Fast forward. I just kind of talked about my previous role as City Council President, and I represented one of the most diverse districts in the city of Philadelphia. And one would think Center City, which I represented, didn't have this kind of problem. But believe me, you had a very similar problem with nuisance establishments in Center City and Philadelphia throughout the district. So this is not, and I've since learned that it's not a Philly issue, it's a statewide issue in communities across the state. So he talked about two particular programs, and we do have some things that Tish Albert has been very good in addressing some of those issues with the tools that she was given. The license compliance program and our ability from a regulatory perspective to address those issues as best we can. But the simple matter is that the penalties associated with it, the time frame allows these unfortunate businesses to continue to operate while they go through this 2-year process of renewal. So literally, somebody can get cited for some very bad things, right? And we've had some very bad things, shootings, stabbings, all other types of activities, because these establishments are breeders of crime. We have to literally wait for 2 years at the renewal process to address this in some sort of a permanent way. So it has continued to be a problem. It is very frustrating, and I must tell you, I was actually asked to be on this because I kept complaining about having these establishments throughout the city of Philadelphia, and I complained to the governor when he was running for something, right? It's one of those offices. And he had an opportunity. He said, look, Darrell, you're always running your mouth and complaining about these licensed establishments that are creating problems in the neighborhood. Would you be interested in getting on the Liquor Control Board? And he kind of called my bluff, and I got on. And I want to thank the Senate for confirming my appointment. So I really appreciate it. So being here to actually address these issues is very, very important. So the policy recommendations that were said earlier actually happened as a result of some awesome work by the task force. And I can't say enough about the staff that did the work as legislators, and I guess we can quietly acknowledge that if it not for our staffs, we wouldn't be in a position to do our work. So I really want to commend them for their awesome work. And I really have to commend Mr. Worley and Tish Albert from the PLCB for their awesome work. So I basically would just like to, one, obviously thank you, but two, and I don't like to plead. Last time I've done that when I was running for office, which has been a while ago, but I'm pleading because this is the challenge that we face every day, and you'll hear later on from my former colleague, Councilwoman Bass, who's been a stalwart on dealing with these stop and goes, how important this is to give us an opportunity to address this very, very significant issues. When you'll hear later on from members of the Philadelphia Police Department and the Law Department talk about some of the statistics that this has caused, and as I said earlier, actual deaths that can be attributed to the fact of these establishments being in our neighborhood. So I want to thank you all so much and want to say how much I appreciate you giving us this opportunity to address this very, very significant challenge. Thank you. Thank you, Chairs, Deasy and Fee, and members of the committee. We appreciate you.
Good afternoon, Chairman Deasy, Chair Fee, and members of the House Liquor Control Committee. To paint a better picture of some of the enforcement challenges and also some of the concerns that we have, I'm going to provide my remarks with this testimony. So stop-and-go establishments are businesses that hold restaurant-type liquor licenses. The same type of license as a typical restaurant or eating place that offers prepared food for customers to sit down and enjoy. Unlike typical restaurants, stop-and-go establishments operate under a business model similar to a convenience store, selling various items such as snacks, food, things of that sort. However, they don't offer prepared food. Bottles and cans of beer are sold to go. It's the same with liquor. If the establishment holds a R license, it is often served in disposable cups and served to go. Additionally, many of these establishments circumvent square footage and seating requirements by having some or all the required 30 chairs folded up, oftentimes in a corner or chained in a corner, and not commonly accessible to the public, and only made available for inspection. Stop-and-go establishments use the liquor license for privilege of selling alcohol, even though they do not function as law requires for a restaurant or eating place. Pursuant to the Liquor Code, we investigate and issue citations primarily on violations of the Pennsylvania liquor laws. LCE does not have the authority to cite for other issues that may be observed at licensed establishments, which are enforced by another state or local entity such as health codes, sanitation issues, or local ordinance or violations. The most common liquor code violation occurring at stop-and-go establishments are insufficient food for 30 patrons at one time, insufficient tables and seating for 30 patrons at one time, failure to maintain minimum square footage required for a serving area, expired Department of Health permit, sale of liquor at retail dispenser, sale of liquor to go, operating another business or selling products without the approval of LCB. LCE has made enforcement of violation typically associated with stop-and-go establishments a priority and continue to do so. We devote considerable resources to address these violations within Philadelphia and other counties within the Commonwealth. These types of violations impact the quality of life and safety of residents and communities surrounding stop-and-go establishments. Each complaint received by the public, we do investigate. LCE works closely with Philadelphia Police Department, Philadelphia Health Department, Philadelphia Licensing and Inspection, and also the board to address stop-and-go establishments. In addition to enforcement, LCE officers attempt to educate licensees who may be first-time offenders. Liquor code violations by stop-and-go establishments, which result in citations, follow the same procedural process as any other liquor code violation. The citation goes before an administrative law judge for adjudication. A licensee may waive a hearing or accept a recommended penalty or proceed with the hearing. After a hearing is conducted, an appeal may be sought by the licensee or LCE First with the board, then with the appropriate court of common pleas, then with the Commonwealth Court. Any of these procedural steps may result in delay of a penalty. Further, the penalty for the types of violations noted has a monetary range from $50 to $1,000. While suspension or revocation of the license is possible, it is infrequently imposed for these types of violations. LLC also participates in compliance checks conducted by the board pursuant to Act 44 of 2017. When a licensing analyst inspects whether an establishment is compliant with applicable statutory requirements. If it is determined by a license is not compliant, the statutory requirements that the type of license held, the board is authorized to immediately suspend the licensee authority to sell alcohol for a period of time until the licensee is found to have corrected the deficiencies upon reinspection. However, a licensee who regains the privilege to sell alcohol may or often does become non-compliant again shortly thereafter, requiring yet another compliance check by the board and also LCE pursuant to the law. Moreover, even if a citation for non-compliance is adjudicated, a licensee's operating privilege are not suspended under the license compliance program. The Liquor Code only permits the board's Bureau of Licensing to object to the renewal of such liquor laws license every 2 years. Additionally, the board may only consider adjudicated citations, not pending citations, when making its final decision regarding license renewal. As noted, there are limitations with the enforcement process, and House Bill 1413 represents a good attempt to address many of these limitations. For example, the proposed legislation clarifies what minimum food offering is. A licensee must make available for customers which align with what would typically be expected at a licensed restaurant or eating place. The measure also increases the range of penalties for both tiers of liquor code violations from $250 to $2,000 for most violations, and $2,000 to $10,000 for most serious types of offenses, including sales to minors and intoxicated patrons. For stop-and-go related violations, the proposed legislation imposes mandatory fines and suspension periods, which are increased for repeat offenses, serving as a more effective deterrent. Finally, the proposed legislation streamlines the appeal process for enforcement actions by removing the Court of Common Pleas from the process, allowing decisions of the administrative law judge to be appealed first to the board, then subsequently to the Commonwealth Court. I want to take an opportunity to thank the committee for allowing the Pennsylvania State Police to provide a statement and a testimony with regards to House Bill 1413. Thank you.
Thank you. Any other testimony? Jason?
So, Chief Counsel.
Yeah, thank you, Mr. Chairman. Chief Counsel Jason Worley from the Liquor Control Board. I did put together some written testimony that has been submitted to the committee. It largely mirrors testimony that I had provided in front of the task force. I'd prefer, I think, to just stand on that testimony. I don't want to rehash all of that, but certainly we are here, myself along with Tisha Albert, to answer any questions that the committee may have. I feel like it may be more helpful to explain through answering questions rather than giving a narrative testimony.
Before we begin questions, I also want to recognize Representative Otten, who has joined us virtually as well. So with that said, questions? Chair Fee.
Thank you, everyone. I really appreciate your testimony. Just roughly, how many stop-and-goes are there in this state? I mean, are we talking 100? Are we talking many, many, many?
Based on the data I have, is well over 1,000.
Over 1,000.
Yes.
Yeah.
And, you know, with so many, it sounds like everybody's been working together, which I love, of course. It seems hard to believe we couldn't get a handle around it before throughout these years. But my other question is, if you can fine them for an offense, $2,000 now for a most serious offense or whatever. Can you do that, like, for serving a minor repeatedly? Like, if our law enforcement were in there daily, like, could they be fined daily, just constantly? And does that, like, do we concentrate on that, or?
Yeah, Chair Fee, every 2 weeks we get a board agenda, and invariably on that board agenda there is some establishment across the state of Pennsylvania that is cited for serving a minor, sometimes frequently. We only get to see this when it comes time for license renewal or some other issue as it relates to within that 2-year period. The challenge with the way the statute currently reads is that it takes 2 years, and people continue to function, and it continues to create problems in our neighborhoods and with our young people. So the answer is yes, but the time as it relates to our ability to enforce and then ultimately suspend or terminate that licensee is problematic, and that's been our challenge.
All right, and you believe this piece of legislation we have in front of us will really make a difference?
It's my understanding, and that's why, as they say, always bring a lawyer with you, that it will go a long way towards allowing us to basically deal with those nuisance establishments across the state. And I do want to say that most of our licensees, I think we have around 19,000, are well-functioning licensees. I mean, I don't want to paint a picture that everybody that has an R license or that runs an establishment is bad, because that's just not the case.
Absolutely not.
But there are these individuals that, for whatever reason, they believe it's worth the cost of doing business to pay the small fine. It's like $25, and I'm going to continue to not be in compliance, and it's no problem. So our ability to increase penalties and shorten that timeline in terms of getting to a point where we can actually terminate the license will be very helpful to us across the state.
I think you're absolutely right, because my restaurateurs in Lancaster, when I talk to them, like, they want taking care of the bad actors. Like, you know, when you do things by the book, you want the bad actors to be taken care of. And certainly, I mean, just for the neighborhoods, for the moms, for the grandmas, you know, we certainly need to find a solution. But it's just remarkable to me, after all these years, that they can still do business. But thank you. I really appreciate it.
If I can just add to that too, I think it's worth sort of explaining the difference between what we call under the liquor code enhanced violations versus non-enhanced. The non-enhanced violations are the ones where the range is set at $50 to $1,000. The enhanced violations are when it goes up to $1,000 to $5,000, and you kind of hit the nail on the head with service to minors. That is the sort of quintessential enhanced violation under the liquor code. And if a business is continuing to serve minors, yes, they could be cited for each offense of serving minors. I think probably what becomes the issue, right, is the limited staffing resources of BLCE to be there every day monitoring those things. So to the extent that we can make sure that there's more robust penalties in place for when those violations are noted and enforced, I think that would go a long way. And I think it's also worth noting that those fine amounts haven't been raised for the non-enhanced penalties since 1966, when they were first put in place, and for the enhanced penalties since 1987. So I think it's long overdue for those to be upped, because as Chairman Clark noted, for a lot of licensees, it's essentially become a cost of doing business.
Yeah, it's awful. But I mean, even just doubling them, I'm like, will that be enough to do that? But, you know, then the good players are, it's a tough situation. With the officers, like, how often do they visit these establishments?
So sometimes we do saturation details, where essentially we're visiting licensed establishments and making sure they're in compliance with statutory law. But for the most part, when it's a violation, we do a routine within a year of doing the first routine. So, but like you said, there's several establishments out there. I know you mentioned about our staffing issues. I can say that we are trending in the right direction as far as the Bureau. The last time we testified back in March of 2025, We were somewhere in the ballpark of vacancy rate throughout the Bureau of 32%. I can say today we're down to 22%. One of the things we're doing is being aggressive about recruiting and maintaining dialogue and contact with folks that may have an interest in pursuing LCE. In 2026, we're dealing with a phenomenon where we refer to it as the ghosting phenomenon, where a lot of applicants will sign up for an exam or a test and don't follow through. And one of the things we're doing within recruiting is staying in constant contact with the applicants and having consistent dialogue to keep them engaged throughout the hiring process. And,
It's remarkable to me that you have to do that.
Yeah.
But,
I'm sorry.
yeah.
Apologize. Yes, as I mentioned before, as far as some of our tactics, as far as recruiting applicants, we're just staying engaged with these folks on a constant basis. A lot of times these folks, they'll sign up to take the test, they don't follow through, and we have to go the extra mile by keeping these folks engaged throughout the hiring process. And we're trending in the right direction. Like I said, the last time we testified back in March of 25, we were around 31, 32%. Now we're somewhere in the ballpark around 23% as far as vacancy rate. So we're going to keep plugging along the way and being very assertive about filling these vacancies that we have within our Bureau.
Well, that's great, because I think enforcement sounds key, but all right, I took up enough time. Thank you. I know, I'm so sorry.
All right, next up, we have a list of, if anybody wants on the list, let us know, but next up is Representative Hogan.
Thank you, Chairman. I was going to just kind of highlight some things from the tour since Chairman Clark brought it up, and one of the things was really the staffing issues, so I think that's been discussed. I don't want to go too much into it, but one of the other frustrations I think we ran into with law enforcement is after we rolled up on that first facility where everyone was outside, and I think it was about 11 o'clock in the morning too on like a Wednesday. It was a sunny day, but it was still 11 a.m. on a Wednesday. We didn't really see anybody at any of the other facilities because I guess word got out that law enforcement was out doing the rounds. So the city of Philadelphia, I think, still had some violations in terms of, you know, facilities or health code maintenance, but the owners of these facilities, I'm just going to call them that because I don't really know what else to describe them as other than stop and goes. They must have had a thread going on where they just shut down the shop and they were kind of covering their tracks as quickly as possible. So at least in Philadelphia, that's one of the other challenges with enforcement beyond staffing, but thank you.
Thank you. Rep. Giroux.
Thank you, Chairman. I want to thank the committee for that testimony. My question is, can you guys talk a little bit about non-licensed facilities and your efforts into curbing that issue?
Well, at least from the LCE perspective, we don't have any statutory authority over unlicensed facilities. Obviously, if it's a speakeasy, we get word that they don't have a license. We can enforce aspects of the liquor code with respect to that, but if it's an unlicensed facility, we can't really do much with that.
Some of these unlicensed facilities serve alcohol. So how do you guys?
So you're referring to a speakeasy?
Yes,
okay.
yes.
Yes, in a situation like that, when we get a complaint, we go out and verify whether or not a violation occurred. If a violation occurred, we issue a citation. The citation process is typically with NOV, notice of violation. One of the things that was proposed within this legislation is to eliminate some of the or streamline some of the citation process, because a lot of times if you have one violation which involves a citation, another violation that involves another citation, if the licensee appeals it, or if LC appeals it, that won't show on their record as far as being a violation, for example. That's a concern. One of the things that's mentioned within the legislation is going to address that is which allows for reduced time frames, and also it requires that a prompt hearing is done within 10 days. So we definitely support some of the language within 1413.
Thank you.
Yeah, Rep, just to follow up on that, actually got a request from one of your colleagues in Philly to come down and talk to some licensees that run, you know, good operations. And the concern is that there are people that have no license, they're selling liquor and they're doing all those other things, and ask us to address. So we will have to bring, I explained that we at the PLCB don't have any jurisdiction. So we will have to bring members of the state police, the LCE, down to have that discussion. And I can follow up and tell you what representative it is, and we'll be shortly going down to have that conversation, because it's not fair for a person that's running a functioning business within the compliance program and have somebody making as much or more money because they're not licensed. And speakeasies been around for a long, long time, but there's no reason not to address the problems that they present for our licensees.
Thank you. Next, Representative Malgari.
Thank you, Chairman. First off, thank you to the panelists for your testimony. I really do appreciate that. In my previous life, I worked in the industry, and I actually am very familiar with what a stop and go is. We have them in Montgomery County as well, and they're all across many of the areas across the Commonwealth. I want to thank you for, one, your testimony, and two, I want to thank the makers of the bill, because this is actually a needed piece of legislation to curb some of the negative aspects from these particular operators. However, I do want to ask if part of the issue that we have is with the complement of the liquor control enforcement and how many you have. Do you have enough people to enforce? And then also, what is the local jurisdictions doing as well to try and help as far as maybe zoning or making sure that you're using every tool in the toolbox to be able to have a vibrant business community and make sure that the good operators are the ones that we're holding up and the negative operators are the ones that you're going after. So, if you can
as I
answer
mentioned earlier, we currently have a 25% vacancy rate. I can tell you that just because a district office is located at one area, for example, Philadelphia, that's not indicative of our resources. For example, we have 9 district offices around the Commonwealth. We have the ability to pull resources from other offices to address an issue. So as far as manpower, that's not a concern. Obviously, we want to fill every vacancy, and I feel like we're trending in the right direction. However, we can't just look at one office and say, hey, we don't have enough folks here. Like I said, we have the ability to pull resources from several offices to address an issue.
Yeah, real quick follow-up, and I promise this will be the last time I follow up. I know we do have time restraints. Maybe next panel, you'll hear a current member of City Council that has been addressing this stop-and-go issue for a long, long time, and you reference zoning, and I'm sure she will speak to her attempts and the council's attempts to deal with some of these challenges on a local level. But, you know, we've always been told that it's a state statute that governs a lot of this. So Councilwoman Bass, who's here today, so she'll be able to talk about some of the things that she's been trying to do along with City Council.
Thank you.
Thank you. Next, we have Representative Rigby.
Thank you, Chairman. Thank you, panel. Just curious, I'm listening to the testimonies and seeing what the fines are. It was mentioned, you know, that the fines aren't that hefty and they pay their fine and continue. The more serious violations is a bigger fine. I'm just curious, at what point do we just stop the fining? Should we be looking maybe at like a 3 strikes you're out or a 5 strikes you're out? What's the process for revocation of the license? And how many violations does it take until that happens? Or is this case by case and you know, we got bad actors that continue to be bad actors that can afford to foot the bill for that fine, and maybe if there's something stricter in place, a 3 or 5 strikeout policy, and they lose their license, may push back on some of this. Just some of your thoughts on that.
Yeah, I can speak to that. Under the liquor code as it's currently written for the citation process, penalties in terms of fines are one form that licensees can be penalized, but there is also the latitude there for ALJs to suspend licenses for a number of days as well as revoke. Their authority is broad in terms of discretionary authority. So they generally will evaluate cases based on the facts, and the tendency is to start with a lower or lesser penalty, and then if there's repetitive behavior to kind of build off of that by increasing fines in subsequent cases or possibly suspending. It's probably a rare case where a license is revoked through the ALJ citation process. What is more common is the nuisance bar or the non-renewal process, and that's where the authority of the Bureau of Licensing comes in to object to a license at the time of renewal. They're able to look at the entire citation history, whether there's police incidents that have happened at the establishment. They're able to look at the criminal history of the owners and the managers and raise objections based on those issues. If those objections are substantiated at a administrative hearing, the board then has the authority to non-renew the license, which is basically taking away the authority of the licensee to continue operating at that point. They also have the ability to enter into CLAs or conditional licensing agreements with those licensees that add additional restrictions or place additional restrictions on the operations of the establishment. And those CLAs are a very commonly used tool by the Liquor Control Board. It's a rare case as well that the board jumps right to a non-renewal. They usually try to give a licensee an opportunity to demonstrate that they can correct their behavior. A lot of that, though, is contingent on their good faith demonstration at the hearing that they're putting things in place to try to correct their behavior going forward. So it is kind of different in terms of the citation process versus that non-renewal process. What is difficult is that renewals are on a 2-year cycle. So the Bureau of Licensing only gets to do that evaluation once every 2 years. So there's a lot of time that can pass in between, and a lot of things can continue to happen.
Sorry, if I could just add to that, our licensing compliance program, if a licensee is suspended for the first time, it's typically for 10 days. If they are a repeat offender, that will go to 20 days to 30 days, but they are automatically reviewed at the time of renewal. So even if they were suspended just one time under the licensing compliance, we do look at their license at renewal time.
So the renewal is actually the opportunity for revocation then, by not renewing it.
Or as Jason had mentioned, yeah, just the review process.
Thank you.
Sorry about that. Rep. Bellman.
I just also wanted to note that this legislation creates a routine inspection schedule for any licensee whose license has been administratively suspended through the compliance program but has subsequently regained operating authority, and that these inspections shall continue for a period of 12 months following the most recent administrative suspension period as well. So I just wanted to put that out there.
Thank you.
I just got to follow up. I'm sorry, but if this has been going on for years, what I don't understand is why doesn't the LCB, you know who the bad actors are. I mean, they're not, a restaurant maybe in my county who, serves somebody underage, right? Are they the same folks who have been there for years and doing the same things? Like, how do you not pull their license, or how do you not?
In some cases, it is repeat actors. In some cases, it's a result of the process that's set up in the liquor code. With any of these non-renewal actions, there's a right of appeal to the Court of Common Pleas of the county where the license is located, and they get to apply a de novo standard of review, which means basically they get to look at the case brand new. They're not bound by any of the administrative record or findings of the board. And they can have a completely different outlook on that licensee.
Does that happen very often? Like it goes to that level?
It happens quite frequently because of the fact that there's that right to de novo review. It's rare that a licensee doesn't take that opportunity to appeal. It's kind of a 50-50 shot whether they're going to get the same result that they did before the Liquor Control Board. What we've seen in some cases is that in some counties, the courts look at things a little bit differently in terms of wanting to help a local business rather than taking a strong regulatory stance on operations. So we have had businesses over the years that we've tried through numerous non-renewal cycles to address, and we've been unable to do so because of that hurdle that exists in the liquor code.
And again, just to add, when the compliance program initially started, it was a complaint-driven process, and a lot of that was up to community members to file the complaint. Because of our collaboration with liquor enforcement, local health departments, law enforcement, district attorney's office, and representatives, that has strengthened over the last 2 years. So now we're getting the cooperation and/or the input from the complainants, could be the health department. So we're working jointly with liquor enforcement and other agencies too. So that has definitely helped through the hearing processes as well.
Okay, good, thanks.
Thank you. I got one quick question, one a little longer. HB 1413 will increase fines, but when was the last time that we've increased fines? How long has it been?
So for the non-enhanced violations, they were put in place in 1966, and they haven't been increased ever since. For the enhanced violations, those were added to the liquor code in 1987, and they have not been increased ever since.
So you're talking 40 years and 60 years. It's time to look at that. Okay, I have one other question. In 2006, the Legislative Budget and Finance Committee, upon completing an operational review of the Pennsylvania State Police Bureau of Liquor Control Enforcement, recommended changing the appeal process. The task force in this bill would change the process. How would those changes impact BLCE in the process they follow to close down the establishments, nuisance establishments?
So, so one of the issues we have to establish a bar as a nuisance is you have to prove every violation. As you mentioned before, as far as the citations, if it's not officially adjudicated and that licensee keeps appealing it, it will never show on the record that a violation occurred. So that's a problem. So if you get rid of the de novo process where the attorneys do not have to prove, essentially prove their case twice, that would make it more streamlined in a sense. By getting rid of the court of common pleas, for example, the county court, if it went straight to the appellate court, the Commonwealth court, it would eliminate that middleman step, if that makes sense. So it should streamline, make it a lot quicker in retrospect.
So what is the process with the other legislative agencies?
Currently, I'll let you get that one.
Yeah, I can speak to that. As a sort of a general rule of thumb under the judicial code, with most Commonwealth administrative agencies, the first right of appeal goes to Commonwealth Court, and they are applying an appellate standard of review, which means they're essentially bound by the record that was created at the administrative level, and they are reviewing for errors of law, abuse of discretion, or findings of fact that are not supported by substantial evidence. Because of that, those processes, I feel, tend to be much quicker. The de novo component that exists within the liquor code for citation matters, as well as for license transfers and nuisance bar cases or non-renewals, adds an additional layer that can really lengthen the process. And as Major Bailey said, it essentially makes BLC staff, as well as the staff in my office, present and prove a case twice. So it's very inefficient. It wastes a lot of time, and there can be a very large gap from when we identify an issue in terms of a problematic establishment and being able to get them shut down. I know in my testimony before the task force, I mentioned the 770 Ameribeer case. That's kind of the best example of a non-compliant business that had received 2 different citations for not meeting the minimum requirements for their license. One of those citations, there were 6 different occurrences. At the time of non-renewal, licensing objected. It wasn't until 4 years later that Commonwealth Court upheld our decision. And in the interim, that establishment was able to continue operating.
Anything further? Any further questions? Seeing none, thank you all. We appreciate your testimony today. Very informative.
Thank you, chairs,
Yep, absolutely.
and thank you, committee.
Best wishes to you. Our next panel from Philadelphia City Council. Good afternoon. Thank you for joining us.
Good afternoon. Well, listen, I want to thank you all. I want to start by thanking you all for having me here today for this very important hearing. This is a topic that I've done some work on, well, extensive work on for a number of years now. And it really just cannot be stated enough that we need your help. We desperately need your help. You know, I have been, again, fighting this issue for quite some time. And I want to first thank the sponsors of the bill, Representatives Spellman and Hogan. I also want to thank our chairman, former Council President Clark. And I want to talk a little bit about my experiences with stop and goes in the 8th Council District. My district covers from some of the wealthiest neighborhoods, which includes Chestnut Hill, if you're familiar with that, West Mount Airy, to some of the most impoverished neighborhoods, which includes North Philadelphia and the like. And in those neighborhoods, one of the things that you'll see are these businesses. They are so close together that there are, we timed it, it's roughly less than 3 minutes apart from one to the next in my district. So there's a lot of them, more than 30. And, you know, they're supposed to have seating for 30. They're supposed to have food. They're supposed to have restrooms. And that's because they hold a restaurant license. So these are the expectations of restaurants operating with liquor licenses in the Commonwealth of Pennsylvania. They have none of those. They're often dirty. There are often illegal drug sales going on at the same time, and there's a lot of loitering. And they sell products beyond what you know, we discussed here, which is alcohol. You know, whether shots of liquor or, you know, cans of beer. They also sell products which will allow you to get an extra high. So they sell things like a shot of NyQuil, right? So, you know, like the little packet of NyQuil you can get, which you can mix with vodka or you can mix with the alcoholic beverage of your choice to get an additional high. You know, and all the while they're selling these products, you know, I could be there purchasing an alcoholic beverage, a shot of liquor, whatever, and there could be children, small children, who are purchasing the other products that they sell, which are candy, soda, potato chips, things that children would like. And so they operate almost as if they are a bar, except they allow children. Probably put on my glasses. I wanted to address just a couple of things that I heard from the committee earlier. Representative Hogan mentioned how, you know, as they were touring, there was this sort of, it seemed as if one was notifying the next, that was notifying the next. Folks are in the neighborhood. Folks are coming. I can verify that that's accurate from my experience. And they know me enough by now. So when we go out and we do our tours, we'll hit one, maybe two, and the rest are all closed in the middle of the afternoon, which is very much unusual. They reach out to one another and they shut down because they don't want to be inspected. They don't want you to know what's going on. They don't want any interference into this money-making operation. The other question from Rep. Gerald about non-licensed operators. I know you were talking more specifically about speakeasies, but I want to hone in on that question around licensing because they often operate without city licenses. They may have everything in order with the Commonwealth, but without the city license that they need to operate as a business. I've seen cases myself where you have some of these operators with a license that's been suspended for 3 years, 4 years, 5 years, either suspended or just not renewed. And I'm talking about a city of Philadelphia license. And so it seems to me as if when these licenses lapse, that the state, the Commonwealth's license, should also be connected to that in a way that they really just can't operate, period. So if somehow they're able to skirt by the city, that they wouldn't be able to do the same with the Commonwealth. The other question or issue I wanted to just address is I can't remember exactly who it was who said that they had, I think it was, you might have mentioned stop and goes in Montgomery County. And I have to say, I did not know. We think of it as really a Philadelphia thing, but I'm not glad to hear that there are stop and goes in Montgomery County, but I am glad to be aware that this problem is so much broader and it really does require the Commonwealth's participation in fixing this for all of our residents. Representative Rigby mentioned, should there be a 3 strikes and you're out rule? I would absolutely agree that there should be some sort of limitation because what we have is that a license will be sold to someone else before they even get to the renewal, before they get to an additional conversation about, you've done this wrong, you're out of compliance with that, let's get you in front of a hearing. Before they even get to that point, often it seems as if there's a transference of the license of the business from one party to a family member, to another relative, to a close friend. And so they never really, are held accountable for the type of business that they're operating and really the disruption in the business. One of the things that we heard earlier was about, the level of violence that happens within these businesses. And I can tell you, I walked into a business maybe 3 years ago, 4 years ago, right after the pandemic, and in the early 2020s, and I walked in, and there had just been a fight, and there was blood all over the floor. And so I'm like, okay, somebody go clean this up, pandemic, and everybody was very nervous. There was no effort to clean it up. There was no, level of concern, which was very obviously disconcerting to me. But I have that on video. If anybody would like to see that, I can certainly forward it around and, get it out to you so that you can see what we walked into. And these are things that are happening just on a regular basis. There's so much of it. There's so much of it happening. And this business or this bill is really about closing loopholes. It's not about closing businesses. I would love, love, love for these businesses to be able to operate as restaurants, which they have the license for, and they claim to be. I would love to have them operate as an operating, functioning neighborhood restaurant that, me and my family could go out into our neighborhood and sit down and have a meal and enjoy seeing some of my neighbors from the area. That's what they set up to be and said they were going to be when they signed the documents asking for a liquor license, asking for a restaurant license in the city of Philadelphia. But we need aggressive tools. We need a level of responsibility that we really just don't have at this time. And so any assistance that you all can provide to us would be greatly appreciated. This bill will give local governments clear and enforceable authority to intervene earlier before it escalates into violence, before it escalates into people sort of self-medicating with mixing various products to get their high. And, again, the stop and goes businesses are disproportionately associated with late night and even daytime loitering, illegal tobacco and nicotine sales, underage sales, gun violence and disorder near schools and recreation centers, and municipal enforcement is often reactive and resource intensive. We just don't have the resources on the city level that we need to have. And that's why I'm here today, because we really just need your help. They operate as bad actors, and they simply change business names, licenses, and operating models to avoid any level of accountability. So I certainly hope that we can get your assistance. I'd be happy to answer any questions. And I do want to point out and just go back and underscore that these businesses operate very near to schools, elementary schools, recreation centers, senior centers. I've even seen them near halfway houses, rehab houses, where people are trying desperately to get their lives together, and they're operating and bringing this level of foolishness into our community. So with that, I'd be happy to answer any questions that anyone may have.
Thank you. Questions?
Okay, I have one.
Chair Fee?
I wasn't, okay, I wasn't.
Just real quick, when you said they change license who they are before they're in trouble, but that still has to go through the LCB, right? Like, they have to give the new license, right?
They do, but they know, and they jump the gun. So when they know that they are under scrutiny, under attention, likely to face some sort of repercussion, they will quickly transfer it from husband to wife, to husband and cousin, to brother, to sister, to whoever. They will move that license around, and we've seen it over and over again.
Okay, well, we got to talk to LCB with that one too, because you know
Okay.
who they are, right?
Yeah.
Okay, thanks.
Yes, and I certainly have, as I said, I've been doing this work for quite some time now. I have a list of these businesses in my district. I'd be happy to take folks around if anyone wants to come to Philadelphia to see some of these establishments. And I believe, as former Council President Clark and the chairman said earlier, you just wouldn't believe what you're seeing. You just can't even believe we're operating businesses this way in our communities.
Thank you. I just had a quick one. Like, how many? I was
Sure.
going to ask estimate within your district. How many of these nuisance establishments?
We have at least 30. At least 30. And as I said, they're pretty much condensed to the areas of North Philly, Nicetown, Logan, Germantown has a lot of them, Feltonville, if you're familiar with any of these neighborhoods. But there are some neighborhoods where they don't exist, sort of like our wealthier neighborhoods or more affluent neighborhoods. We don't have these sorts of nuisance businesses. And so I see them as very predatory. They establish and pick the neighborhoods where they feel that they can fly under the radar, that there'll be little to no attention to the way they're operating, so.
Thank you. It's a shame. A small number is so detrimental to the neighborhood.
And they can, one other last thing is that they can completely destroy a commercial corridor. And so we've seen this over and over again. I represent an area which is known as the North 22nd Street Shopping District. We have 3 or 4 of them on that corridor alone, and it's really decimated the business in the area.
We have Representative Giral.
Thank you, Chairman. Thank you, Councilwoman, for all your testimony and your
Thank you.
efforts to ending this issue in Philadelphia. My question is basically, how do they get around the local ordinances in Philly with the zoning? Like, how does that come into play? Can you explain that to the rest of the committee?
Certainly. Well, the zoning code is pretty liberal, and so the zoning is the ability to what you can put where. And so, as a retail establishment, there's no connection to you have to be or you can only operate as a stop and go restaurant, this or that. There's just so many things that you can be with certain zoning codes, and often the zoning code is already in place when they pick an establishment. It's not like say, for example, if you want to build a multi-unit apartment building and it's only zoned for a single-family home. It's not the same. The zoning around commercial use I find to be much more liberal, particularly on commercial corridors, and it allows it to be much more prevalent that you'll see this kind of establishment come into play.
Thank you.
You're welcome.
Anyone else? Seeing none?
Thank you for your time.
Okay.
Thank you to the
Thank you.
committee.
Appreciate you being here.
Absolutely.
Next, we have the City of Philadelphia. Good afternoon. Thank you for joining us.
Good afternoon. Good afternoon, Chair Member Deasy, Chair Member Fee, and other members of the Committee on Liquor Control. My name is Kristen Bray, and I am Chief Legal Counsel to Mayor Sherelle L. Parker and the Director of Philly Stat 360. On behalf of Mayor Parker, thank you for allowing the City of Philadelphia to voice its overall support for Bill 1413, making certain amendments to the Pennsylvania Liquor Code to enhance enforcement against nuisance liquor establishments, including those colloquially known as stop-and-go liquor establishments in Pennsylvania. House Bill 1413 recognizes a reality that Philadelphia has experienced for decades. While most licensed businesses are good neighbors, a small number repeatedly violate the law and create disproportionate harm. In particular, these establishments known as stop-and-goes do not follow basic requirements of the law, such as maintaining adequate seating or serving food. They, in turn, become hotspots for nuisances and potential criminal activity, which is a drain on police resources, it frustrates residents, and diminishes public confidence in our government and enforcement systems. The City of Philadelphia commends the sponsors of this bill for confronting this issue head-on. The stakes here are not abstract. When nuisance establishments persist, they destabilize communities, invite disorder, drive away responsible investment, and place strains on city services. Most importantly, however, they make residents feel unsafe in their homes and where their children play and go to school. Over the past several years, Philadelphia has taken a comprehensive and data-led approach to address nuisance businesses to help eradicate the harm that non-compliant businesses cause. Through the Nuisance Business Committee that I lead, Philadelphia routinely reviews neighborhood complaints and businesses with chronic violations. Philadelphia's nuisance enforcement model uses that data it has to engage in a comprehensive enforcement strategy and coordinate efforts across multiple city departments, including health, licenses and inspections, police, 311, commerce, and law, to name just a few. Using every enforcement tool available to us, we work with businesses to prioritize voluntary compliance. We emphasize business education using warnings and encouraging businesses to voluntarily engage in corrective action when there are behaviors that are harming communities. When those tools that are geared at gaining voluntary compliance fail, the city is prepared to engage in robust enforcement that include the imposition of fines, the imposition of cease operation orders that close a business until compliance occurs, the revocation of business licenses that we issue, sometimes taking business owners to court, sometimes physically sealing off buildings, and sometimes cutting off the utilities to businesses that repeatedly flout the laws of Philadelphia. Collectively, these efforts have helped more businesses become good neighbors while ensuring that long-standing nuisances businesses cease to operate recklessly in Philadelphia. The lessons learned from Philadelphia's experience are simple: a comprehensive, cohesive enforcement strategy that allows reliance on every enforcement tool available to address long-standing nuisance problems in communities works. However, there is one enforcement tool that Philadelphia does not have, and it holds us back. Aside from having to bring a complicated, timely lawsuit in the courts, Philadelphia has no ability to directly and timely enforce the Liquor Code's requirements. Instead, we are reliant on the Pennsylvania State Police Bureau of Liquor Control Enforcement and the Liquor Control Board, both of which are understaffed and overworked to enforce. This sometimes results in spotty and untimely enforcement, which in turn has led to significant non-compliance with the Liquor Code requirements in Philadelphia, and that in turn has allowed nuisance businesses to persist without consequence. Explicitly authorizing Philadelphia to co-enforce the Liquor Code with our state partners would only serve to enhance the Commonwealth's statewide enforcement scheme. It would ensure faster and more consistent accountability, and most importantly, it would allow Philadelphia to protect our own neighborhoods. We recognize that our colleagues at the Pennsylvania State Police Bureau of Liquor Control Enforcement and the Liquor Control Board have been good, willing, and excellent partners with us over the years. However, their resources are limited and spread thin across many municipalities. Permitting Philadelphia to supplement their efforts can only lead to stronger, more consistent enforcement, which will give us safer communities. As you will hear from my colleague, through the police department, the City of Philadelphia stands ready to contribute significant resources to this enforcement effort by providing video or other evidence gathered at noncompliant businesses. When our police and enforcement agencies see a noncompliant business, we need to be able to act quickly and enforce the law. We cannot wait weeks or months while the community is destabilized or to wait for an inspection to occur. Allowing local enforcement agencies in Philadelphia to concurrently enforce the liquor code closes enforcement gaps, protects compliant businesses, and ensures accountability for those who repeatedly and flagrantly disregard the law. To that end, I would like to address House Bill 1413's language on requiring tax compliance. I believe it goes without saying that compliance with local tax obligations is not an extraordinary burden. It is a basic expectation for every person and every business in this Commonwealth that they pay their taxes and they pay their taxes on time. Further, it has been our experience that non-payment of taxes often indicates broader management or compliance issues in a business. Holding a liquor license is a privilege, not a right. Ensuring that all licensees are current on taxes or enrolled and keeping up with payment agreements helps uphold fairness and prevents habitual offenders from gaining a competitive edge. In conclusion, as you will hear from my colleague here today, House Bill 1413 moves in the right direction by tightening up loopholes in the liquor code. However, I urge this committee to strengthen the bill to explicitly allow the City of Philadelphia to concurrently enforce the liquor code alongside of our partners at the Pennsylvania State Police Bureau of Liquor Control Enforcement and the Liquor Control Board. Allowing local enforcement will ensure chronic violators face real accountability. Philadelphians deserve neighborhoods where responsible businesses thrive and bad operators face consequences. We can give Philadelphians just that by allowing Philadelphia, which has the infrastructure, experience, coordinated enforcement strategy, the ability to directly police and protect its communities. This concludes my testimony.
Thank you. Good afternoon. Good afternoon, Chair Member Deasy and Co-Chair Fee, other members of the Committee on Liquor, Liquor Control, and the bill sponsors. My name is Deputy Commissioner Francis Healy. I'm a Deputy Commissioner, Chief of Staff for Commissioner Bethel, and I oversee legal affairs for the Philadelphia Police Department. First, on behalf of the Commissioner, I'd like to thank you for allowing the department to be here and voice its opinion or in general support for Bill 1413, making certain amendments to the liquor code and to address the issues surrounding the stop-and-go establishments in Pennsylvania. As we know, stop-and-go, we've heard multiple times today, refer to establishments operating under an R or E license that disregard their requirements to serve prepared food, maintain at least 30 seats on premises for dining, and provide restroom access to customers. These establishments are not functioning restaurants or eateries. Rather, they operate primarily as takeout alcohol outlets selling beer, wine, and small amounts of liquor to go with little consideration of the surrounding community. These businesses are probably this most impactful. The businesses are disproportionately concentrated in economically disadvantaged, densely populated neighborhoods, particularly in cities such as Philadelphia and I believe Pittsburgh. Councilmember Bass just laid to that. Those areas she identified were those areas, in fact. We don't see them throughout the city. These are targeted in certain neighborhoods. This illicit business model has a direct and harmful effect, obviously, on our nearby communities. Patrons with no place to sit inside oftentimes consume the alcohol immediately outside the establishments and in the residential areas, which contributes to the obvious loitering, public intoxication, disorderly conduct, public urination, and other criminal activities. These conditions obviously erode the quality of life for our residents and only exacerbate the existing inequities that threaten these communities and their safety and place an ongoing burden on the families and businesses in the immediate area. As such, Mayor Parker and the City of Philadelphia Police Department sincerely appreciates the sponsors of this legislation for their leadership and willingness to address this issue that significantly impacts our communities. This bill represents a meaningful step forward towards improving the life of some of our most distressed neighborhoods. While the police department fully supports the intent of this legislation, from a law enforcement perspective, we're respectfully going to offer several recommendations that we believe could enhance its effectiveness and strengthen its impact based on the operators that we know in Philadelphia. I'll address these provisions slightly out of order, but first discussing Section 3 of the Bill 1413, and then I'll return to the definition sections that are critical for the effective enforcement. First, Section 3 directly addresses the core of the stop-and-go business model by clearly establishing the minimum requirements related to seating, food, service, and other operating standards, along with immediate consequences for the failure to meet those requirements. While these requirements already exist, they are often embedded within the licensing definitions during the approval process rather than articulated as enforceable provisions with clear immediate penalties. Section 3 importantly bridges the gap between licensing and enforcement, a change that is greatly appreciated from a law enforcement perspective. This inclusion of immediate suspension authority is essential and will significantly alter the behavior of these establishments by creating real and timely accountability. Strengthening enforcement of the minimum requirements is commendable. However, its effectiveness depends on the enforcement authority reflected on the ground. In Section 3, only LCB licensing, a Bureau of Licensing is authorized to inspect and enforce this new provision, while neither Bureau of Liquor Control Enforcement nor local enforcement is even mentioned. This represents an excellent opportunity to foster collaboration between the licensing authorities and the law enforcement, creating synergy that could maximize the effectiveness of this bill. For the city, this is a critical and necessary component of enforcement. As mentioned earlier, and for all our agencies, the number of LCB licensing agents is understandably limited, and physical inspections by the small workforce can be time-consuming, potentially undermining the purpose of this bill, which is to impose immediate consequences for deficiencies and minimum requirements. By contrast, the Philadelphia Police Department and my officers are routinely on scene, responding to calls for service related to disorderly conduct, as I mentioned, noise complaints, assaults, and other incidents directly tied to these stop-and-go establishments. Most importantly, all Philadelphia Police Departments our police officers are now equipped with body-worn cameras, providing objective, time-stamped video evidence that could be clearly document the violations of licensing requirements. Officers can easily record the entire interior of these establishments. This evidence could be securely shared with the LCB Bureau of Licensing within hours, eliminating the need for specific licensing by licensing agents to rely solely on physical inspections. The Bureau could still make the final determinations regarding deficiencies and suspensions, but the process could be greatly expedited. Officers who record these violations would be available to testify, to authenticate these videos, and for any administrative hearings or appeal panels. As such, we would respectfully recommend considering amending the current land to provide explicit authority for the LCB Bureau of Licensing to accept evidence from the Philadelphia Police Department, in addition to on-scene inspections by the licensing agents. This will allow enforcement decisions to be timely, efficient, and directly tied to the observations, thereby fulfilling the core purpose of this legislation, which is ensuring immediate accountability for noncompliance. This brings me to the second recommendation. And I say this from a law enforcement perspective, so I hope I don't offend anybody by this, but I know the operators and the actors in Philadelphia, and that's what my recommendation is based upon. This brings me to the second recommendation, which concerns the current definition of eating place in restaurants. In Section 1, the terms accessible and available were intended to clarify the table and chair requirements that most people with common sense would seem sufficient. However, in our experience in Philadelphia, stop-and-go owners have intentionally structured their operations to exploit ambiguities in the current liquor code. While the general public might understand what's in this bill and what's required, we believe these terms are still vague enough to create opportunities for abuse. From an enforcement perspective, an officer entering one of these establishments should be able to immediately determine whether it's operating in compliance. Chairs and tables must not merely be accessible or available in a technical sense. They must be properly arranged so patrons can walk in and immediately sit at a table. Stacking chairs, as Bureau of Liquor Control Enforcement mentioned, stacking chairs in a corner or leaving tables unusable could arguably meet this current definition of accessible and available, creating the loophole that these businesses operators will exploit to ensure clarity and prevent confusion. And I say this because these individuals need very, very specific instructions so they can't wiggle around. So to that available, so in the relevant sections of both the eating place and restaurant in Sections 1, we would recommend deleting the accessible and available definitions with the following. This is just a recommendation. Such tables and chairs shall be physically present on the premises, fully assembled and arranged for immediate use by patrons during all hours in which alcoholic beverages are served. That's kind of clear cut. If I walk in there with a police camera, I can tell you whether you have the tables in place or you don't, and that's the key. So in conclusion, with House Bill 413, is a great step forward toward addressing the challenges posed by the stop-and-go establishment and helping to improve our quality of life in our most impacted communities. The Police Department, Philadelphia Police Department, fully supports the intent of this legislation and greatly appreciates the thoughtful work of the sponsors. From a law enforcement perspective, we have offered recommendations, particularly around clarifying definitions and incorporating timely enforceable mechanisms that will leverage the police-obtained evidence that we believe could help strengthen the bill's effectiveness and help ensure immediate accountability. This concludes my testimony, but I would like to answer one question. Representative Fee, you mentioned how these businesses are allowed to operate. I don't think we got to the nitty-gritty. Councilmember Bass touched upon it. The bottom line is these are all corporations or LLCs. So what they do is they close one LLC, open another LLC with the same players. So the issue is it goes over and over and over again. In Philadelphia, the IRS does have certain provisions called attribution rules. So bad things attribute to other people in a tax code. We are trying to do something in Philadelphia. It's only preliminary now with using an attribution type system where if you have penalties on a previous owner and they own a substantial portion of a new business, the penalties come with you. You just can't get rid of them, and that may stop some of the nonsense. But that's how they're able to do this. It's not like the liquor board just letting this go. They're new corporations, and by law, they are new entities, and they start with a fresh board every time they do, and they know when the bad stuff's coming, and they just form up a new LLC. And you look at the ownership; it's all the same people. They may change the players around a little bit, but they're all the same players. But that's how that's done legally. That concludes my testimony, and I'm happy to answer any questions you may have.
Thank you. Is there any questions? Yes, Rep. Major.
Hi, thank you, Chairman. I have a question about zoning. I thought maybe you could answer it. Is it not a possibility for the city of Philadelphia to change their zoning ordinances? I keep hearing about the chairs and the tables being an issue. Could you not require that through zoning for these establishments, and then also use zoning enforcement to enforce these rules?
That's a great question, Representative. So once zoning goes to the use of establishment. Am I running a restaurant? Am I running a automobile repair shop? And that zoning code then tells me and informs what my building and fire code requirements are under the International Commercial Code. Construction Code. Once I get a zoning permit for my facility, I don't have to change that until I am changing the use. So if I am switching from a school to a grocery store, that is a completely different use, and I would need to get a new zoning permit. If I'm changing from a restaurant that sells seafood to a steakhouse, though, I do not need to get a new zoning permit because under the zoning code, I am having the same essential use for purposes of the safety codes, the fire codes, and the building codes. Further, once I have a zoning permit, if we change the zoning district around a particular establishment, I can become a non-conforming use. And under Pennsylvania law, a non-conforming use can grow and expand, which then allows them to essentially operate in certain ways outside of the regulations that we might already have. Zoning is a great tool to use when we don't have a business in place, but it is not a good tool to use in terms of businesses that are already existing.
Thank you for the clarification. Thank you.
Representative Rigby.
Yeah, I'm just thinking outside the box here. I'm sorry. Post-COVID, a lot less diners, a lot more catering. I have a business in my district who does an amazing catering business. They've reduced the amount of tables and chairs they have. Quite honestly, they filled up with skilled machines, but they've reduced. Is 30? I mean, that's the number I guess was set whenever. A lot less people are doing the dining out, and there's 20 different apps you can go to order your food and have it delivered. I'm wondering if we should be looking at the number of seats also when we're addressing this, because I know post-COVID there's a lot less that are dining out. And again, with the skills games, he's using that to supplement too, but does an amazing business, does a ton of catering. Rarely is anybody sitting in there eating, though, and I'm just wondering how that's going to affect. In your areas, the Philadelphias or the Pittsburghs, you're seeing a big problem with it. I haven't had complaints or concerns, and I'm trying to think of my smaller guys, and how's this going to affect them if we start rolling this stuff out?
Well-
Or do we pilot the programs maybe to those two bigger cities and see what's happening there and then move it forward?
Right, with respect to the seating, just so you know, the bar stools count for that, they count. So a lot of these bars, they'll have 10 bar stools, but one table. They still don't meet it, but I see what your point is, yes.
And I would add, we all know what a restaurant looks like. We've been to them, we've experienced them. When we go to a restaurant, we're breaking bread and we're in community with our family members, we're in community with our neighbors, we're in community with our friends. What we see at Stop and Goes is there's not a single table and chair. There's not a single bar stool, because these establishments are not operating as true restaurants when they're not having that aspect of community that you have in a restaurant where you're sitting down and breaking bread with your neighbors. Instead, what they have is a candy counter or something else that is blocked off by plexiglass, completely locked away, and a narrow alleyway where we often have people who are engaging in criminal behavior or are using it essentially as the beehive to engage in the criminal behavior out on the street. So I think that's a good point, but we're talking about establishments that simply have no seating and no chairs at all.
Rep Fee? Chair Fee.
So, the things that happen out in the street that are probably illegal or, public urination, I don't know, whatever. Like, your officers can respond to that, though, correct?
Yes, my officers do.
And they do.
Yes, and we have a nuisance, and actually, Council Member Bass actually introduced a responsible business ordinance several years ago, and it's going towards their business license, their Philadelphia business license, whereas it's 3 strikes, basically it's a 3-strike rule, basically, in Philadelphia for chronic nuisances. If we make arrests in and around those locations that there's a nexus to the bar, like the individual just seen coming out, or we can tell they just came out of the place, and we'll cite the owner. If we cite the owners 3 times within a year, then their license is a notice of intent to cease operations. So we're going after their personal license, but oftentimes it takes 3 shots. We've expanded that recently for violence that we're seeing in those locations. So instead of 3 bad acts within a year, if there's a homicide, a shooting, a rape, or something along those lines, that's deemed an immediate nuisance, and we'll investigate that immediately and then try to put that into the notice of injunction.
It's a one-strike rule for the aggravated assaults and the rapes and homicides, something like that. In addition, we have other provisions of our code that if a business is being used to sell or distribute drugs or serve alcohol to minors, we can cease and impose a cease operations order immediately for those higher levels of crime.
So you can, if they're selling alcohol to a minor, you can shut down the establishment, or it still has to go to?
Therein lies the rub. Okay, the issue is this is a state law or a state entity. I can't shut it down in Philadelphia. I can take their underlying business license away, but not their liquor license. So that's how we try to attack it. So we're going after their business licenses the best we possibly can. And as was mentioned before, we're using everything in our arsenal. The only thing is we don't have, what's missing is that connection with the state. Like, we have a lot of resources that we can actually help with the enforcement process, like understanding that you have to come out and do an inspection from a LCB or the Bureau of Liquor Control Enforcement. But you have to look at today's realities. I have body cameras. Every one of my cops can go in there, sees everything you want to see, and it's documented with timestamp data. I can send that. We can use that as verifiable evidence. I have the officers that will be available to testify to support it. It's just the idea of using us as to create the synergy, because the state doesn't have the resource, and nobody has the resource, and we don't have it alone either. So we're relying on the help from LCB and the state police, but together, using what we have, my officers are already out there. Something goes on, they go in there, they take a 360 view of what's going on, and it may not be complete non-compliance, but I'll be able to tell you whether they have the chairs or everything like that, and that can get the ball rolling, and I can basically hand that off to LCB, and they can work with it, and they make the final decision. They need additional information, happy to supply it, but there's a nexus there between us and the state that use our stuff, and we're happy to help.
Okay, Representative Fee, if I could, one of the arguments we will see when we attempt to enforce something using our business privilege license, or that's in a certain way related to liquor license violations, is that people who are feeling the effects of our enforcement action will say we are preempted from enforcing anything under the liquor code, and that only the Liquor Control Board and the Pennsylvania State Police can enforce, which puts us significantly behind the 8 ball when we are trying to enforce these bad behaviors.
Okay, thank you.
You're welcome.
Thank you. Rep. Bellman.
I just wanted to thank you for your testimony today, and thank you for the recommendations as well. It was very thought out. And I just also wanted to note that that a lot of the times that these establishments are in compliance when they actually get their license, and then they operate out of compliance once they have their license. So as much as we can do to enforce it and enforce the laws on the books, that is going to be very helpful. So thank you.
Yeah. No, and I did say that's the point what was mentioned earlier when they did the tour. They called one, they were all closed down. That's where the benefit of having the police department readily available. We get the video before they shut down.
Thank you. Thank you for your testimony. We appreciate your time today, being
Thank
here.
you very much. Appreciate it. Thank you.
Next, we will move to panel 4, PA Licensed Beverage and Taverns Association, as well as PA Restaurant and Lodging Association. Chuck here? Oh, okay. We are joined virtually by Chuck from the Tavern Association. You hear us, Chuck? Chuck, your microphone on? Okay.
Can you hear me now?
Yeah, we got you. We got you.
Oh, great. That's wonderful. Okay. Chairman Deasy, Chairwoman Fee, members of the House Liquor Control Committee, thank you for inviting the Pennsylvania Licensed Beverage and Tavern Association to provide testimony on a concerning issue and related legislation. That issue is what we all know as stop and goes. We commend the chair and members for taking this problem seriously and working to do something to take state action to get these places under control or closed where appropriate. The PLBTA, often just called the Pennsylvania Tavern Association, represents Pennsylvania's small business, family-owned taverns, bars, and licensed restaurants across the state. And it wasn't long ago that we testified in Philadelphia in front of the Stop and Go Legislative Task Force. Most of what I'm about to say we included in that testimony. This time, though, I will focus our testimony on specific parts of HB 1413. But since this issue originates in Philadelphia, I want to first mention another growing issue that I'm hearing from my Philadelphia members. There is a growing concern about the use of fake IDs that are so good that they can trick a scanning device. We're no longer talking about your father's fake IDs that were easy for bouncers and bartenders to identify. One of my members is so concerned that they could be tricked into serving a minor that they no longer allow anyone under the age of 25 in their establishment. This establishment took that measure to protect community and their license while turning away legal business from those aged 21 to 24. It's just simply too easy for an 18-year-old to get a fake ID through websites. I hope at some point the legislature will also look at this issue. Now back to the stop and go issue. As you've heard all day here, in a nutshell, the stop and goes are businesses, often a convenience store or deli that somehow found a way to qualify for and purchase a liquor license. They regularly violate well-known and established parts of the liquor code, such as food requirements and seating. And it's not unusual for them to serve minors and VIPs, very intoxicated persons. Furthermore, there has been a history of health and safety issues within these businesses, despite the requirement that they have current and valid health licenses. The negative things happening inside these establishments act like a magnet to bring in the wrong crowds into those communities, often associated with criminal activities such as illegal drugs and gang activity, and again, negatively impacting those neighborhoods. As an association representing small business bars, taverns, and licensed restaurants, we wonder how these businesses ever qualified for a liquor license in the first place. For sure, they're given all R, H, and E licensees a black eye, and that needs to change. HB 1413 would make changes in several areas that could be helpful. First, HB 1413 will strengthen the compliance program. essentially reinforcing what good our licensees across the state are already doing. For example, the overwhelming majority of our H&E licenses have food menus with many options and offer plenty of seating to serve no less than 30 individuals. These are base standards for the industry in Pennsylvania that seem to be regularly violated by stop-and-go locations. And again, we wonder how those establishments ever qualified in the first place. HB 1413 tweaks the liquor code to require substantial food offerings to constitute a meal. It also reinforces seating for 30 patrons when alcohol is sold. Since law-abiding RH&E licensees are already doing that, we don't see this as a problem and can support it. The bill also increases fines for all citations. As you heard, at the moment, fines can be as low as 50 or as high as 5,000 for the most serious violations, such as serving minors. That range was probably considered high when those levels were decided a very long time ago, so it's understandable that those fines should be under consideration for increases so we can support those changes. One area of House Bill 1413 where we remain cautious is the proposal to eliminate the de novo review at the County Court of Common Pleas. And as we said a few years ago to the task force, we don't want to see any collateral damage to law-abiding licensees. Under current law, local judges have the ability to hear these cases fresh, to consider new evidence, listen to local law enforcement, neighborhood residents, and licensees, and make independent findings of fact based on those conditions in those communities. That perspective matters. Common Pleas judges understand the unique dynamics of communities across state in a way that a statewide court simply cannot. Removing this step does not change a legal process. It removes a layer of community-based accountability. While we appreciate the desire to streamline enforcement and reduce delays, efficiencies do not come at the expense of due process of local decision-making. Licensees would lose an established legal right, and communities would lose a forum where local impacts can be fully heard. We also note that either party can already retains the ability to appeal to Commonwealth Court, meaning there is already a mechanism for state consistency. For these reasons, we remain neutral on this provision and respectfully suggest continued dialogue on alternatives such as expedited common pleas timelines or targeted application to chronic violators that preserve local authority while improving enforcement efficiency. Finally, while liquor code reform is an important step, stop-and-go locations reflect broader challenges involving community health, crime, and illegal drug activities. Simply removing a liquor license may not fully resolve these problems in those communities that have been described earlier in this hearing. Without strong local policing and coordinated neighborhood interventions, bad actors will resurface. We thank the committee for including the Tavern Association in this discussion and reaffirm our commitment to working collaboratively with the General Assembly and the PLCB on solutions that clean up problems while protecting responsible small businesses across Pennsylvania. Thank you.
Thank you, Chuck. Lauren?
Good afternoon, Chairman Deasy, Chairwoman Fee, members of the House Liquor Control Committee. My name is Lauren Brinjack, and I'm the Senior Director of Legislative Affairs for the Pennsylvania Restaurant and Lodging Association. PRLA represents thousands of liquor licensees across the Commonwealth, from your local taverns and pizzerias to large brands to the small town diner that just secured its first liquor license and is looking to grow its footprint in Pennsylvania. Thank you for hearing our testimony today regarding House Bill 1413. PRLA appreciates and we understand the intent of House Bill 1413. We share the General Assembly's goal of addressing the proliferation of stop-and-goes, which we know are problematic for the communities in which they exist. We are concerned, however, that parts of this legislation as drafted will do more to complicate operations for some licensees who are trying to comply with the liquor code than to stop these nuisance establishments, which, as we've heard all day today, are already operating outside of the law and violating numerous provisions of the liquor code. To this point, during the joint informational hearing on stop-and-goes last year with the Senate Law and Justice Committee and this committee, much of the conversation centered around the need for more personnel and resources to enforce the existing law. We continue to believe that enforcement of existing statutes is the most direct way to address chronic problem establishments without creating new compliance traps for responsible operators and licensees. Regarding this piece of legislation specifically, we respectfully request the committee consider the following. Under the current draft of this legislation, the definition of eating place and restaurant would be amended to add language regarding seating and food and menu requirements that we believe as written would prohibit licensees, and especially, again, our smaller operators, from engaging in some common industry practices such as closing all or some of a dining room during later hours of operation, as well as closing or significantly limiting kitchen operations before closing the bar. These changes would translate into real operational challenges for licensees, including increased staffing and operational costs for our legitimate operators, while we think still failing to address those nuisance establishments that have never maintained true dine-in accommodations in the first place. Secondly, and this has come up several times, HB 1413 proposes a restructuring of the appeal process to the disadvantage of the licensee by eliminating involvement by local courts of common pleas and sending any appeal of the PLCB's determination regarding the refusal or withholding of a license renewal or transfer directly to Commonwealth Court. We believe this has the potential to significantly limit a licensee's ability to pursue or challenge the board's decision about a license objection or renewal, and we believe this creates a due process issue for licensees. In addition, this legislation would impose immediate and mandatory license suspension for failure to maintain seating, food, and other requirements. We understand where this is coming from, and we obviously support all licensees adhering to the requirements for licensure. However, we're concerned that these penalties fail to account for mitigating or unintentional circumstances that aren't the result of repeated attempts to evade the law, but rather operational challenges. And I'm thinking, for example, of the small restaurant that had to reconfigure its dining room on the fly after significant damage to the exterior of its building, and for a period of time inadvertently failed to have the correct number of seats. Under this new language, that licensee would have had, at a minimum, a mandatory suspension of 10 days of their license, been forced to have an administrative hearing, and potentially be subject to additional penalties. We feel that this is overly harsh for situations that are accidental or circumstantial, rather than ongoing intentional efforts to subvert the liquor code. And finally, this legislation adds a local requirement with respect to obtaining the tax clearances necessary to renew, transfer, or otherwise maintain a license, and we are concerned by the addition of another layer that could delay a license renewal. And I can personally attest to this. As it stands now, our licensees often face significant difficulty and confusion obtaining their tax clearances, even when they are up to date on their taxes. And so additional local requirements, we think, risk compounding delays that can threaten the continued operation of otherwise compliant businesses. So in closing, we appreciate the opportunity to testify at this hearing. We appreciate the committee's time and attention to this issue, and we urge careful consideration of this legislation to avoid any what we know are unintended consequences that could penalize responsible licensees. Thank you for your time.
Thank you. Questions? Yeah, go ahead, Joe. You look like you're dying to say something.
I was not, but but I haven't spoke today, so I guess the chairman is putting me on the spot. No, particularly I feel for you whenever it comes to like closing a kitchen, you know, as hours get later into the evening. My family owned an establishment for 25 years, and you know that even though they were open until 2 a.m., they closed that kitchen at 11. And are you saying that overall that this would eliminate that capacity?
The way that we're reading it, I think it would. There's probably a way to further refine it. As our members, and I guess as you know, the orders for the kitchen significantly drop off between 9 and 10 p.m. Our members are concerned that the way this legislation is currently written, they might have to keep a full kitchen staff or a much larger kitchen staff than they otherwise would have, who may not be doing anything in order to be able to prepare a full entree or a full meal for a customer who's probably not going to order one, who probably just wants French fries.
Seeing none? Thank you.
Thank you.
Appreciate you being here. Thank you, Chuck, for joining us.
Thank you, Representative Deasy and Chairwoman Fee.
Next, we have panel 5 will be joining us virtually, I believe. Pittsburgh Nuisance Bar Task Force.
Hello, can you see me?
Yes, we got you.
Hi, Sergeant Lerza with Pittsburgh Police. I'm the coordinator for the Nuisance Bar Task Force for the city of Pittsburgh.
Thank you for joining us. You have testimony for us today?
Not so much testimony. I'm just want to thank everybody for inviting us. We don't have so much of a stop and go problem like obviously the city of Philadelphia does. We do have similar issues in our downtown corridor. Commander Novosel and Lieutenant Monticelli are also on the call. They've dealt with that more directly than I have with the downtown corridor. I've been doing this since 2021. Any kind of help with enforcement and compliance is definitely needed. It's as far as even the non-renewal process with the LCB, it's very frustrating. Like they covered before with appeals and certain things like that. It makes it a very frustrating process. But as far as this HB 1413, it definitely will help us in the long run.
Thank you. Are you seeing a spike in these type of facilities in Pittsburgh? Obviously, as you mentioned, in Philadelphia, it's been centered upon here for the last 2 hours, but has this activity picked up in Pittsburgh as well?
Yeah, so I don't know if Commander Novosel wants to drop in on this, but we've had a couple incidents downtown with a couple different locations where it's pretty similar to what Philadelphia is experiencing.
Yeah, I could attest to this a little bit. We have a lot of stores that actually, they sell single servings to basically some of the unhoused population. They come in, they hang out outside. They don't have any room for they don't serve food. Maybe some are starting to serve food, like maybe hot dogs or things like that, but they don't really have any place to sit. So some of the unhoused population just comes in, buys a beer, goes right around their business where the corner, sits there and drinks it, panhandles, and goes right back in, and then they become disorderly, sometimes intoxicated, and the cycle just keeps continuing. I think probably in the last, I would say 2-3 years, we've gone from like 1 or 2 to probably like 10 now, 10 and maybe more, with just how many six-pack shops do we have now?
Six-pack and smoke. If you do six-pack and smoke shops, there's 36 of them.
They don't all serve beer though, just the ones that serve beer.
But I'll get a list of those.
We can get a list that just serve beer, but they do exactly, I guess, the same thing as the stop and goes what you guys were talking about, and it's really caused a lot of issues because exactly what you said. We have some people serving beer, as in the morning when kids are in there trying to buy candy and they're selling single cigarettes. It's the same thing, and it just sometimes there's even a line, kids and adults. So that does cause a major issue with us.
We had a period last summer where we had a new six-pack shop opening every 2 weeks.
I will say they are not, like I said, you said someone on this call said that they're dirty. They're very kept, but they also sell the slushies too, which is a big deal for us when they just walk around with an open container of like a slushie and we can't even really cite them for it. I think that's pretty much it for us.
What would your the significance of the food requirement be in this bill to shut down these establishments?
I think that would be huge. For the first part, if they actually had something inside where the people would stay in there and drink the beverage there without leaving, that would help us out a lot. I mean, if they had to do that, I think that would be a big deal because then it would be something where we could actually cite them for, and where now they have nothing. They just let people come in and they don't even absorb it, and we have to deal with the problem outside. That's the big issue for us.
Very few of our establishments meet the earlier talked about 30-person seating, 30-person food, or probably the square footage requirements. Almost very few of our establishments actually would come close to meeting that requirement.
As we heard around the Philadelphia establishments, do you have significant detrimental impacts to the neighborhood outside of some of these places as well?
Absolutely. Like I said, what happens is it creates more panhandlers. They can panhandle right across the street to get enough money and then go and buy their alcohol, become intoxicated, because some of the higher beverage alcohol, become intoxicated, go back, get more money, and by the mid-lunch, we have 4 or 5 people sitting there that are extremely intoxicated, causing us many problems.
We have 1 block or 2 blocks on one of our streets downtown that has 5 of these shops. And that is where we have a significant amount of people congregating, and they're just everywhere all day long, drinking on the street, drinking in the alleyway. And we cite individuals repeatedly for open container public intox, but it doesn't change the conduct just because there's summary citations.
And these are all mixed in with bus stops. We have 4 schools downtown too, also with juveniles and the cigarette smoking, and then we got the other problem with Delta 8 and 10 that some of these beer distributors also sell.
Every single one of our beer stores also sells THCA, Delta 8, Delta 9, Delta 10 products, all marketed as legal products.
Yeah, there's some dangerous products available to kids and everything else. Is there any questions, further questions? Seeing none. Thank you, gentlemen. We appreciate your patience in joining us today and appreciate your insight into the great city of Pittsburgh. So thank you for being with us today. With that said, any other further comments or questions? Chair Fee?
No, just thank you.
Thank you. Thank you for everyone being here. A lot of great testimony and certainly a lot of work still to be done, but recognize Representative Bellman for his work. He's done a great job on the issue. We appreciate you being here today. And
Thank you. Appreciate it.
and Representative Hogan as well. So with that said, today's hearing is adjourned. Thank you.